screen. I know sometimes you get those little yellow boxes where the WebEx items block the screen, so I try to get them off the screen to the best of my ability. Anyway, so Kristen O'Neill with the New York State Committee on Open Government. Our role here is to provide advice and guidance regarding the New York State open government statutes, including the Freedom of Information Law, the Open Meetings Law, and the Personal Privacy Protection Law. Today we're talking about the Freedom of Information Law. If anyone has any questions about FOIL, you're always welcome to contact our office. You can ask for me directly, but there are other attorneys in the office that can assist you as well. Our phone number for our office is 518-474-2518, and our website is www.opengovernment.ny.gov. The New York State Freedom of Information Law is codified in Public Officers Law Article 6. You can always find a copy of it on our website. We try to keep that as up-to-date as possible, so hopefully the version that you see on our website should always reflect the most current version of the statute. Same is true for the Open Meetings Law. If you're up on the screen, you'll see sort of what our website looks like. We have drop-down menus for the Freedom of Information Law, the Open Meetings Law. Under each of these drop-down menus, you'll see a copy of the statute, the Freedom of Information Law. You'll see a copy of our regulations, our advisory opinions, our case law summaries. We have items, we have a contact us page, news items, and this big banner here is often where we put the most important information of the day, so to speak. So if there's been any updates to any of the statutes, for example, the Open Meetings Law, the ability to hold remote meetings was extended again through July 14th, 2022, because Governor Hochul extended the declared disaster emergency through that date. So as long as the declared disaster emergency is in effect right now, public bodies will continue to be able to have remote meetings. Going back to the Freedom of Information Law, the original statute was enacted in 1974. It's really limited in scope. You had access to 9 categories of records. And if the record you were seeking was not included in those 9 categories of records, then you were essentially out of luck. You would not be able to obtain them through the Freedom of Information Law. That version of the statute was not particularly popular, and it was repealed and replaced with what is essentially the current version of the statute in 1978. And that current version of the statute is based on a presumption of access. So you start with the assumption that all government records are subject to the Freedom of Information Law, that they are all subject to FOIL disclosure, and then the agency has an obligation to review those records to determine whether the records or portions of the records fit into one of the permissible grounds for denial. Who is covered by FOIL? FOIL governs access to agency records. And the term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or any one or more municipalities thereof, except the judiciary or the state legislature. So in everyday, simple terms, agencies are agencies under the governor's office. For example, New York State agencies, the Department of State, Department of Health, Department of Labor, all of those government agencies that are under the executive at the state level are agencies subject to FOIL. Then you get into local governments, counties, cities, towns, villages, school districts, water districts, sewer districts, public libraries. All of those entities are agencies subject to FOIL. The courts are not subject to FOIL. The courts are exempt from the requirements of the Freedom of Information Law. They are not agencies that are required to respond to a FOIL request. And that doesn't mean that many court records aren't publicly available. It just means that FOIL is not the mechanism for obtaining those records. The state legislature is also not included in the definition of agency, but they are subject to FOIL requirements in a very limited capacity. They are subject to FOIL in the same way that agencies were subject to FOIL back in 1974. The law includes a list of the types of records that you are permitted to obtain through the Freedom of Information Law from the state legislature, and if it's not on that list, FOIL is not going to govern access to those records. Every agency subject to FOIL is required to appoint one or more records access officers. The governing body of a public corporation, the head of an executive agency or governing body, shall be responsible for ensuring compliance with the regulations herein. So the records access officer is not the only person employed by an agency that has an obligation to comply with the Freedom of Information Law. All government employees and officials are required to comply with FOIL. It's just that the records access officer is the individual that has been designated to be the point person, so to speak, for responding and coordinating an agency's response to a FOIL request. The records access officer is the person to whom a FOIL request must be made. You can't submit a FOIL request to any random public employee. You have to make it through the appropriate avenues through the records access officer that has been designated by the agency. The agency has to provide a business address and an email address. The law states when requests are accepted via email, they must provide an email address, but all agencies at this point should be able to accept FOIL requests via email. The term record under the Freedom of Information Law is very broad. It means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. And then the definition goes on to include examples. But as I said, the definition is very broad, and it means information in any physical form whatsoever, regardless of whether or not an agency is required to prepare that record or create or maintain that record. Once it's been created, once comes into the possession of an agency, it is a record subject to rights of access under the Freedom of Information Law. An agency is not required to create new records or to answer questions in response to a Freedom of Information Law request. To that extent, the term freedom of information is somewhat of a misnomer because it's not access to information, it's access to records. It's an access to records statute. So in response to a FOIL request, no agency is ever going to be required to create a new record in order to respond to a FOIL request. It does not mean that an agency is not required to make copies of records or to convert records to a preferred format if possible. It just means you're not required, an agency is not required to create that record from scratch. There are 3 exceptions to that rule. The first is that every agency is required to create and maintain a record of how each member of a public body votes in at any public meeting. They're required to create and maintain and make available a list of the names, public office address, title, and salary of all public employees and officials. And every agency is required to create and maintain a reasonably detailed subject matter list. Many municipalities adopt the record retention and disposition schedule established by the New York State Archives as their subject matter list, and this is permissible and appropriate because they line up quite nicely. So I talked about the difference between creating a new record, how an agency is not required to create a new record, versus the concept of preparing a copy of a record. The law states that an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have such copy made by engaging in outside professional service. So for example, here's a situation, if an agency maintains a record in electronic format and it can be emailed to the requester and the person would like it in that electronic format, the agency must provide the applicant with the record in electronic format. If an agency maintains only paper copies of a record, but has the ability to, for example, scan the records just as easily as it would be to photocopy the records, then the agency would be obligated to scan the records and either email them or place them on an electronic storage device and provide them to the applicant if they have the ability to do so. The third distinction between creating a new record and preparing a copy of a record is that the law states when the agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so, and it shall not be deemed to be the preparation or creation of a new record. So if an agency has the ability to query its database and produce a record that contains the information being sought, even if it's not a record that's produced in regular course of business, it would be required to do so. In terms of the responsibilities that an applicant for records has, the applicant has an obligation to, 1, put its request in writing, and 2, to reasonably describe the records sought. So in determining whether the applicant reasonably described the records sought, the first question is, can their agency locate or retrieve the record with reasonable effort? The answer will likely be different depending on whether those records are paper or electronic records, as it's much simpler to search an electronic database of records or to search through electronic records than it is to search through paper records. So for example, if an agency, it used to be not that long ago, the Committee on Open Government, when we received copies of appeal determinations, when an agency receives a FOIL appeal and issues an appeal determinations, it is required by law to provide the Committee on Open Government with a copy of the appeal and the appeal determination. When we received those documents, we would review them, and then they would, often we would be getting them in paper format, and they would get filed in a filing cabinet by date received. We did not log them until the past couple of years. We did not have an electronic log. They just simply got placed in a filing cabinet after we reviewed them. So if someone came to us and made a Freedom of Information Law request, for example, for copies of all appeal determinations issued by the City of Albany, we would have it would be very difficult. It would require more than a reasonable effort to locate those appeal determinations because we didn't have a log. It would require searching through every appeal determination we received over a given time period, and we'd have to review each individual one to determine whether it had been issued by the City of Albany. We didn't file them by agency. We filed them by date received. So if you made a FOIL request for copies of all appeal determinations received in June 2018, if at that point, if we still had them pursuant to our record retention period, we would be able to locate them with reasonable effort because that's the way we filed our records. Now we have an electronic database. It's simply an Excel file, but we log the appeals as they come in. So when someone makes a FOIL request for copies of appeal determinations issued by the City of Albany, hopefully it's as simple as doing a search function in our Excel file for when those documents were received, and then we can locate them. So that's just an example of an applicant's obligation to reasonably describe the records sought. Time limits. When an agency receives a Freedom of Information Law request, they have certain time limits that govern the manner in which they must respond. The first time limit that comes into play is 5 business days. An agency is required to do something within the first 5 business days. They must either provide access to the records sought, deny access to the records sought, state we don't have the record that you're seeking, or acknowledge the request and say it needs more time. If an agency acknowledges the request and states that it needs more time, it's required to give a date by which it plans to respond. Generally, sort of the rule of thumb is that it shouldn't take more than 20 business days to respond. An acknowledgement stating that we plan to respond within 20 business days, sort of a standard, and it would require no additional explanation under the law. However, if an agency requires more than 20 business days to respond to a Freedom of Information Law request, it is required to provide a date certain by which it plans to respond that is reasonable given the circumstances of the request, and the agency is required to give an explanation for why it needs that additional time. It might be the volume of a particular request or the complexity of the given request, the amount of time it will take legal staff to review to determine rights of access. But whatever the date certain is, it must be reasonable given the circumstances. Agencies should not be engaging in repeated extensions that don't give the requester a clear expectation of when they will receive a full response. If an applicant receives a denial of access, the applicant has 30 calendar days to appeal the denial. Once the agency receives an appeal of a denial, it has 10 business days to respond to that appeal. Email requests. This is getting a little bit dated, but I remind everybody anyway because there are some agencies that still are not aware of this requirement. If an agency is able, it must accept FOIL requests by email. In my opinion, every agency should be able to accept requests by email. An agency cannot require a requester to use its form, but it can require that a request be made in writing. So there's nothing wrong with an agency making a form available for the public to use when making a FOIL request. I think many people appreciate the ease of a form, but it cannot require that the requester use its form. If an agency receives a written Freedom of Information Law request, either via mail or by email, it should not be putting any additional burdens on the applicant to fill out the form. If, for example, if an agency receives a FOIL request in writing, it should never go back to the applicant and say, fill out this form first. It should just accept that the applicant has met its obligations under the statute and start processing the request. In fact, unless there are personal privacy concerns relating to the content of the records, an applicant for records should be permitted to remain anonymous. If someone wants to make a Freedom of Information Law request for records that would be public to everyone, they could make it from an email account that says janedoe@gmail.com is requesting a copy of the contract between the city and a particular vendor. A record that would be available to anyone, and the identity of the applicant who is seeking a copy of that contract is irrelevant, and they should not be forced. If they choose to remain anonymous, they should be allowed to do so. There are, of course, exceptions to this rule when there are personal privacy concerns, but generally, an applicant for record should be permitted to remain anonymous if they choose to do so. There are two types of situations that give rise to the right to file an administrative appeal. One is where there's an express or affirmative denial of access, and that is where a record is possessed by an agency and is being withheld in whole or in part. A second situation that gives rise to the right to file an administrative appeal is a constructive denial of access, and that's when an agency fails to respond to a request within the time limit set forth in statute. So, for example, if an agency receives a FOIL request and no acknowledgement is provided within 5 business days, the applicant can treat that failure to acknowledge the request as a constructive denial of access and file an administrative appeal. The same would be true if an agency acknowledges the request and states that we will provide a response on or before 20 business days from now. And that 20 business days comes and goes when the agency has failed to provide a response to the request. Those are situations that can be deemed to be a constructive denial of access, and the applicant would have the right to treat it as a denial and file an administrative appeal. We have model language. The Committee on Open Government has model language on our website for both types of appeals. So then we get into sort of the nitty-gritty. As I talked about in the beginning, an agency with freedom of information law is based on a presumption of access that all records are public unless they fit into one of the permissible grounds for denial. So now we're going to start talking about what some of those permissible grounds for denial are. I'm not going to go over each one in great detail. Anytime there's a situation where someone is has questions about whether a particular ground for denial applies, they're always welcome to reach out to our office and we can have that conversation. But right now I want to go over some of the more frequent examples. In addition to this program being recorded and being posted, it will be posted online hopefully by the end of next week. I also have these PowerPoints are available on our website. There's a section right from our homepage. If you scroll down our webpage, our website, you'll find a link to a section called Training Materials and Recordings, I believe is what it's called. If you click on that link, it will bring you to my PowerPoint, and it will bring you to links to recordings of our training programs. So up on these slides, you will see that I've included the different grounds for denial that are included in the statute. But we're going to start talking about just some of them today. So the first ground for denial that comes up are where a record or portion of record is exempt from freedom of information law by state or federal statute. And there are a couple of examples here. One is, for example, communications between a government agency and its legal counsel. If an employee or official from a government agency reaches out to its attorney to request legal advice and the attorney responds by providing legal advice, that set of communications is going to be exempt from FOIL disclosure via the attorney-client privilege. And the attorney-client privilege is codified in New York State statute, so it is exempt from FOIL disclosure pursuant to state statutes. Another example is student education records. Student education records are made confidential pursuant to the Family Educational Rights and Privacy Act, or FERPA, and that is a federal statute that makes those records confidential. So if you made a Freedom of Information Law request to a public school district or a community college or a CUNY or a SUNY university for a particular individual's student education records, you would not be able to obtain them under the Freedom of Information Law because they are exempt from disclosure by federal statute. Mental health records are confidential pursuant to mental hygiene law. Autopsy records are confidential pursuant to a provision of New York State county law. County-operated E911 records, including recordings and transcripts of those calls, are also confidential pursuant to New York State county law. And Social Security numbers are confidential pursuant to New York State Public Officers Law, Section 96A. So those are just some examples of records or portions of records maintained by a government agency that would be exempt from FOIL disclosure pursuant to some other state or federal statute. Another exception to rights of access under FOIL is when disclosure would constitute an unwarranted invasion of personal privacy. Some examples here are employment applications of individuals that were not hired to fill up a position in public employment. So you have a position open and you receive 10 applications, but only one individual is hired. The names and employment history of the individuals that were not chosen for employment generally can be withheld as an unwarranted invasion of personal privacy. Home telephone numbers or personal cell phone numbers of either public employees or any member of the public where that information has come into the possession of a government agency can be withheld on personal privacy grounds. If there's medical information maintained by a government agency, either again about a member of the public or a public employee or official, that information can be withheld on privacy grounds. Public employees' home addresses can be withheld on privacy grounds. Lists of names and addresses of natural persons, if that information would be used for solicitation or fundraising purposes, could be withheld on personal privacy grounds. An example here of this would be a situation if someone made a FOIL request to the records access officer for a town for the names and addresses of all individuals to whom dog licenses have been issued for the past 10 years. The records access officer could require that the applicant certify that they will not use that information for solicitation or fundraising purposes. So if the person making the request, like for example, owned a mobile dog grooming business, and the only reason they wanted that information was because they wanted to send out mailers soliciting business for their new company, their new mobile dog grooming company, the FOIL request for that information could be denied on personal privacy grounds. A fairly recent amendment to FOIL are mugshots. If you make a Freedom of Information Law request to a law enforcement agency for a copy of an individual's mugshot, that mugshot can be withheld on personal privacy grounds. And here I'll point out that other than records that are confidential by some other state or federal statute, all of these exceptions to rights of access are permissive, meaning an agency can withhold, but is not required to withhold. So for example, if a law enforcement agency had a legitimate law enforcement purpose for disclosing a mugshot, for example, they wanted to get public input, they wanted to post somebody's mugshot and say, please be on the lookout for this individual, they're not prohibited from disclosing that information. It's just that if a FOIL request is made for a copy of an individual's mugshot, it can be withheld on personal privacy grounds. And here I'll also note that public employees enjoy a lesser degree of privacy than the general public. Law enforcement records. So if an agency wishes to withhold records or portions of records pursuant to the law enforcement exception, it has to meet a two-part test. And the first part of the test is that the record must be compiled for law enforcement purposes. And there's recent case law that indicates that it doesn't matter why the records were originally created. It matters whether these records were compiled by the time of the FOIL request for a law enforcement purpose. And I'll explain what I mean by this. Is the case law in question had to do with an individual who worked under the former Cuomo administration. And at a certain point, there was an investigation by the United States Department of Justice. And that the Department of Justice requested copies of the employees' time and attendance records. Now, time and attendance records generally are not going to be considered records that are compiled for law enforcement purposes because they are records that we use in the normal course of business for administrative record keeping. They are not generally considered to be law enforcement records. However, in this case, by the time the New York Times made a FOIL request for those time cards, for those time and attendance records, they had been requested and compiled. They had been compiled by the governor's office for the Department of Justice for a law enforcement purpose. So they fell under that compiled for law enforcement purposes exception. Also, the compiled for law enforcement purposes does not just apply to criminal law enforcement purposes. It also applies to civil law enforcement purposes. So that's the first part of the test, that the records are compiled for law enforcement purposes. The second part of the test is that disclosure would have to cause one of the harms envisioned by the statute. So for example, would disclosure interfere with a law enforcement investigation or judicial proceeding? If an agency wishes to assert that harm as the reason for withholding the records, but the agency itself is not the one conducting the investigation, there's a fairly recent amendment to the statute that requires that the agency that receives the request must go to the agency that is conducting the investigation and receive confirmation from that law enforcement agency that disclosure of the records would interfere with the investigation. The second harm is that disclosure would deprive a person of a right to a fair trial or impartial adjudication. Disclosure would identify a confidential source or disclose confidential information relating to a criminal investigation, or it would reveal non-routine criminal investigative techniques or procedures. So for example, a law enforcement agency is not required to disclose the type of technique or procedure that would allow an individual to evade law enforcement detection or to perhaps successfully get away with a crime that they wouldn't otherwise get away with. Another very common exception to right of access is intra-agency and inter-agency material. This ground for denial is intended to protect the deliberative process. So for example, if you have individuals that all work within a single government agency, such as, I work with the Department of State, if I am emailing my coworkers and we are discussing a particular issue and trying to come up with the best strategy for dealing with a particular problem or how to respond to a request for an advisory opinion, those emails where we deliberate can be withheld as intra-agency material. However, if any of those communications contain statistical or factual tabulations or data, instructions to staff that affect the public, final agency policies or determinations, or external audits, including audits conducted by the Office of the State Comptroller, those records would need to be disclosed. So to the last point, for example, if the Office of the State Comptroller conducts an audit of a particular city government agency, there will be eventually an audit prepared by the Office of the State Comptroller and sent to that city agency. That must be disclosed. The law specifically says even though it's a communication from one agency to another agency and might otherwise be considered inter-agency material, the law states no, it's an external audit, including one conducted by the Office of the State Comptroller, must be disclosed. When an agency responds to a FOIL request by indicating that it does not possess the records sought, this is not a denial of access that gives rise to the right to an administrative appeal. What it does give rise to is the right to request a certification to that effect. So Section 89(3)(a) of FOIL states in part that upon payment of or offer to pay the fee, prescribed entity shall provide a copy of such record and certify to the correctness of such copy, or it shall certify that it does not have possession of such record or that such record cannot be found after a diligent search. So that's sort of a two-part provision. One is that if you receive a copy of a record and you want to be sure that the copy that you received accurately reflects the content of the original document, you can request a certification to that effect. If an agency states that they do not have the records that are responsive to the request or that they cannot be found after a diligent search, you can request a certification to that effect. If an applicant requests that type of certification, it is the agency is required to provide it. So here we're going to go back to the idea of the right to appeal. When an applicant is denied access to a record or any portion of a record, including a single redaction on a single page, an applicant has 30 calendar days to appeal that denial. So first I'll note that the agency has an obligation to put that denial in writing and must provide a reason for the denial. then the applicant has 30 calendar days to appeal that denial. The FOIL appeals officer, by statute, is the head or governing body of the agency or the person or persons designated by the head or governing body. The FOIL appeals officer cannot be the same as the records access officer. Within 10 business days of receiving the appeal, the FOIL appeals officer must either provide the records sought or fully explain the reasons for further denial. And sometimes it's a combination of both those situations. So if the FOIL appeals officer agrees with part of the original determination, but disagrees with another part of the determination, they might order disclosure of one of the withheld records, but say, no, we agree, and we're going to provide an explanation as to fully explain why we're continuing to withhold these other records. The law does not contemplate a remand back to the records access officer. It is the responsibility of the FOIL appeals officer to review those records at the appeal level. And here again, I'll note again that the agency is required to send a copy of the appeal and the appeal determination to the Committee on Open Government. If we have any agency reps on the phone, just so you know, it's perfectly acceptable to do that via email. You're welcome to email us at coog@dos.ny.gov with copies of the appeals and the appeal determinations, and save yourself the postage. Fees. So this is something that trips up a lot of agencies in terms of what they are permitted to charge in terms of copies. The first thing to keep in mind is the law only allows an agency to charge a fee for the cost of making a copy. It does not permit agencies to charge a fee for search time or the administrative costs involved in responding to FOIL requests. The law only allows reimbursement for the cost of making copies. And then it establishes two different fee structures. These fee structures cannot be combined. The first is for photocopies for documents up to 9 by 14 inches. If it is a piece of paper up to 9 by 14 inches, an agency is permitted to charge 25 cents per photocopy. The agency may not charge for search time. It cannot charge for review time. It cannot charge for the time it takes an agency to review the records to determine rights of access. It cannot charge for the time it takes to make the photocopies. It is only permitted to charge 25 cents per photocopy. That's it, end of story. The second fee structure is for records either larger, paper records larger than 9 by 14 inches, or for records in some other format, like video or audio or data. And in that case, the law states that an agency may pass along a fee of the actual cost of reproduction for all other records. And then it establishes what the agency is permitted to consider in determining the actual cost of reproduction. Here, many people that know a little bit about FOIL have heard about the 2-hour rule. And this is what trips people up, because many entities try to charge that 2-hour rule for situations where the 2-hour rule does not apply. So for example, if you're making photocopies, you can throw the 2-hour rule out the window, because the 2-hour rule will never come into play if you're making photocopies. You're only going to be able to charge the 25 cents per photocopy. On the other hand, if instead of making photocopies, an agency is scanning records or is extracting data from a database, it could charge the salary of the lowest paid employee capable of preparing the copy, but only if it takes at least 2 hours to prepare the copy. So for example, if it takes 2 hours or 3 hours to scan all of the responsive records, the agency could charge the salary of the lowest paid employee capable of performing the scanning, multiplied by the number of hours it took them to do the scanning. If it only took an employee 30 minutes to do the scanning, there will be no fee that can be charged. In addition, an agency can pass along the cost of any electronic storage device, such as a CD, DVD, or thumb drive that is needed to store the electronic copies of the records. An agency can pass along the cost of having a copy made by a third-party vendor if the agency does not have the technology available in-house to make the copy itself. So if you have blueprints or maps, something like that, that needs to be sent out to a third-party vendor, whatever the third-party vendor is charging the agency, that cost can be passed along to the applicant. Again, an agency cannot charge for search time. It cannot charge for review time. It can only charge for the actual cost of making the copy. Let's see. I'm trying to forget. I feel like there's one other thing I wanted to mention here. Well, anyway, if it comes back to me, I'll go back to this issue. But I do know that the fee issue trips people up on a fairly regular basis. So if anyone has questions about what fees are permissible, you're always welcome to reach out to our office. Enforcement. Enforcement of the Freedom of Information Law is through a Civil Practice Law and Rules Article 78 proceeding. The Committee on Open Government does not have enforcement authority. We do not have the authority to investigate complaints or to compel an agency or a public body to take certain actions. We can provide advice, we can provide legal opinions, but our opinions are not binding. We only have the, we can provide you guidance, we can point people in the right direction, but our opinions are not binding, and we do not have enforcement authority. Enforcement is through the courts. If a petitioner brings an Article 78 proceeding against an agency and the petitioner prevails, attorney's fees are mandatory on the part of the judge when the requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. Attorney's fees are going to be discretionary on the part of the judge when the requester has substantially prevailed and the agency failed to respond to a request or appeal in the statutory time limit. So finally, I'll note again, I know I gave my email address at the beginning of the program, but I want to note that we do have other attorneys in the office that can assist. So you're always welcome to call our office. That's what we're here for. Whether you're a government employee, whether you're a member of the public, whether you're a media representative, everyone is welcome to call our office with questions about the Freedom of Information Law and the Open Meetings Law. That's our telephone number, 518-474-2518. And that's our office email account. So no matter, even if someone's on vacation or at the office, someone will always be monitoring that email account and be responding to inquiries as quickly as possible. And we do try to get back to people pretty quickly because we know sometimes your questions are very time sensitive. So thank you for your time. But now I'm just going to go and I'm going to stop sharing my screen so I can go back to our chat function so I can look to see if people had questions that they would like answered before we log off. Let's see, someone had a question about whether publicly chartered entities like the Port Authority or utilities. Public authorities are subject to the Freedom of Information Law. The Port Authority, we're talking about the New York, New Jersey Port Authority. It's an interesting situation because multi-state agencies are often not subject to the New York State Freedom of Information Law because we cannot force another state to comply with New York State statute. But there is a law in effect specifically relating to the New York, New Jersey Port Authority that requires the Port Authority to both comply with the New York State Freedom of Information Law and the New Jersey Access to Records statute. This person also asks about whether records include notes made by an official for their own use. Record is defined very, very broadly. It is any information in any physical form whatsoever, which would include somebody who writes handwritten notes on a notepad. Whether those records need to be disclosed or not is going to depend on content, but they are records subject to FOIL. Just a second here. Another question is, are FOIL requests subject to FOIL? The answer is yes. If someone wants to make a Freedom of Information Law request for copies of all FOIL requests that were submitted in the past year, they can do so. Under most circumstances, that's going to be public information. There might be limited personal privacy exceptions. I mean, certainly perhaps if the FOIL request includes home addresses, home telephone numbers, personal email accounts, perhaps those could be redacted. If for some reason a FOIL request is very, very personal in nature, perhaps relates to a domestic incident or something of that nature, it doesn't happen very frequently. But if, for example, a FOIL request does involve something of a personal nature, in those limited circumstances, perhaps the name of the person who made the request could be redacted. Someone asked, are there exceptions with respect to police reports? You know, there is, as I said, there's no like black and white rules. You know, I did talk about the law enforcement exception, so hopefully that answered some of the questions, but there are no black and white rules. Unless a record is specifically prohibited from disclosure by some other statute, there's always going to be some sort of subjective review that requires an agency to look to determine whether an agency, whether disclosure of an aspect of a document would cause one of the harms that is described in the statute. Someone asks, how may a FOIL officer respond to a request for all emails between any member of the Board of Trustees and any member of the public for a period of 15 years? Well, an argument could be made that the person who's making the request has not reasonably described the record sought, because it may be nearly impossible for a municipality to locate all of the responsive records with reasonable effort. It depends on the record-keeping system, depends on how long emails are maintained, obviously. You know, if you don't maintain your records, your emails for 15 years, that might actually be a good thing under these circumstances. It's going to depend on what amount of effort would be involved in locating those records. So as you might have gotten the gist from here, there aren't black and white answers to a lot of FOIL questions. Because the grounds for denial are permissive, unless a court has weighed in on a particular issue, there's often going to be a subjective analysis as to whether a record can be withheld or a portion of a record can be withheld. Another question asks if I could explain more about the creation of a record versus searching a database and providing the information. So if an agency maintains a database and is able to query the database, basically input and make a request to the database for it to produce the data elements that are being requested, it must. On the other hand, if it would require, in order to produce the data elements that are being requested, would involve an entire reprogramming and would involve the agency to have IT staff add additional functionality to a database that did not exist before, I don't think they're required to do that. But if the existing database is able to be queried to produce the data that is being requested, the agency must produce that data unless another ground for denial can be asserted. And again, this is true. I mean, they must do that even if it's not a report that is prepared in the normal course of business, even if it's not something that they've already produced and have available in an Excel file or some sort of report that they've been producing for the past 10 years. If they have the ability to query that database and produce the data elements, it must. Someone asked about who would be considered a FOIL appeals officer in a town clerk's office. So you don't want to limit it to the town's clerk's offices, you're going to limit it to the town. So often this is what the laws and regulations state is that every agency is required to A, appoint a records access officer, and B, appoint a FOIL appeals officer. And there can be more than one at each level, but they're required to appoint each one. So every municipality, since the law has been in effect for going on 50 years now, this should already be in place for most municipalities. Almost every municipality should have a policy. They're required by law to have a policy in place relating to FOIL. So the first place to look is to look at the town's FOIL policy or local law or code to determine what their local law says, what their policy says about who is the FOIL appeals officer. So let's say, which is true in 99% of the time, that the town clerk serves as the town's records access officer. The law states that the head or governing body or the individual designated by the head or governing body of the agency serves as the FOIL appeals officer. So perhaps at the town level, the town board is the governing body. The town board could collectively act as FOIL appeals officer. They could appoint the town supervisor as FOIL appeals officer. They could appoint the town attorney as FOIL appeals officer. It is at their discretion, but they do need to appoint someone other than the records access officer to act as FOIL appeals officer. So when asked if I had recommendations for how to handle continued delays by agencies, should you appeal? And I think that's a good way. If you have submitted a FOIL request and the agency continues to respond month after month after month by delaying responding to your request, a good way of responding, or a good way of maybe pushing the agency along would be to file an administrative appeal arguing that they have not met their obligation to respond, to provide a date certain and that is reasonable under the circumstances. That would be, in my opinion, that would be a good basis for an appeal if you continue to receive continued delays in responding to your FOIL request. If they respond by, I mean, the upside is they might respond by saying, yep, you know what, we have been a little bit dragging our feet here. Here's the records you asked for. Another example might be, no, we think the delays that we've engaged in are reasonable given the circumstances of your request. We're denying your appeal. At that point, the remedy would be to initiate an Article 78 proceeding in state Supreme Court. This is a good question. Does an agency have to notify the applicant if they're going to hit the 2-hour rule in charge? Anytime an agency is going to have to charge a fee pursuant to that second fee structure, they are obligated to notify the applicant upfront what the fee is going to be. So I think it's a good policy to always notify an applicant what the fee is going to be before an agency sort of incurs the cost. But what the law states is if it's anything other than photocopies 9 by 14 inches, you're required by law to notify the applicant upfront what that fee is going to be. And that gives the applicant the opportunity to say, you know, that was more than I anticipated. Maybe I can narrow the scope of my request. Let's talk about this. How can I narrow the scope of my request? But yes, an agency is required to notify if they're going to use the 2-hour rule for records other than photocopy to prepare a copy of a record. They do have to notify you up front. What is the penalty if a FOIL isn't responded to within 20 business days? We talked about that's a constructive denial of access, and the applicant has the right to file an administrative appeal. It doesn't really matter why the agency failed to respond. It could be, you know, just clearly an administrative oversight. It could have just been, you know, something fell through the cracks. Honestly, it could be that it went into a spam folder. It doesn't really matter. But, you know, if the agency received a FOIL request, if it was directed to the appropriate person, if it was directed to the appropriate email address, and the agency fails to respond within that 20 business days or acknowledge within 5 business days, then it can be treated as a denial of access, and the applicant has the right to file an administrative appeal. So I think we've come to the end of our questions, but of course, everyone that's on the line right now knows that if something else comes up, you're always welcome to contact us with additional questions, and we hope to be a resource for the public, for the media, for the government employees that need to deal with FOIL, and we hope we can be that resource for you. Hope you all have a great summer, and enjoy your day. Thank you very much.